USSR 30 years could not break through to its place at the UN. This is 30 years of illegitimate work of the UN. Article author Vestemira, Svetlana Ferris. Is there continuity or succession and identity, for purposes of international law, between the former Soviet Union and the Russian Federation? December 8, 1991 another coup d'état took place, B. Yeltsin, L. Kravchuk and S. Shushkevich, as former heads of republics, usurped all power in the USSR during the transition period for opposing purposes that did not correspond to the results of the USSR All-Union referendum of March 17, 1991. And they made a false statement about the alleged downfall of the USSR in their illegitimate document the Belovezsky Agreement, which was signed on behalf of the Republic of Belarus, BSSR. RSFSR and Ukraine, Ukrainian SSR, to create the Commonwealth of Independent States, CIS. In the preamble of this document, they stated, I quote, that the USSR, as a subject of international law and a geopolitical reality, is ceasing to exist. The logical legal conclusion that should have been drawn from this statement thus seems to be clear. With the demise of the Soviet Union itself, its membership in the UN should have automatically lapsed and Russian Federation, more precisely, the RSFSR, should have been admitted to membership in the same way as the other newly independent republics, except for Belarus and Ukraine. As already stated by the UN General Assembly's Sixth Committee in 1947. The rights and obligations of membership of a state cease to exist, with its extinction as a legal person internationally recognized as such. Therefore, Yeltsin's letter to the UN dated December 24, 1991 stating that the Russian Federation continues the membership of the Soviet Union in the UN should have been rejected by the UN Secretary-General. But the UN Secretary-General accepted this illegitimate letter with an illegal demand in it. Thus, the UN has been working illegitimately for the past 30 years, because 1. In fact, the UN clearly saw that illegitimate persons changed the name, coat of arms, flag of the country and changed the country's constitutional system to the opposite from Soviet socialist to capitalist. And at the same time, the UN recognized these illegitimate persons with these cardinal changes as the successor of the USSR. Although the UN was notified of the holding of an all-union referendum of the USSR of March 17, 1991 and its results, where the Soviet people spoke out for the preservation of the USSR, and therefore for the preservation of the name, coat of arms, flag of the country and the constitutional system of the country, Soviet Socialist. Therefore, the Russian Federation cannot be the successor or continuator of the USSR. 2. One republic. The RSFSR is not equal to the whole Union, that is, the USSR. And therefore it cannot replace the whole Union in UN and cannot be the successor or continuator of the entire Union. 3. Moreover, the Russian Federation does not exist at all. See my synopsis in the Pill on USSR case, and therefore it cannot be the successor or continuator of the USSR. 4. In addition, the Russian Federation declared itself independent from the USSR. Because the Russian Federation is part of the Commonwealth of Independent States, CIS, and therefore it cannot be the successor or continuator of the USSR. 5. Also, the Commonwealth of Independent States, CIS, cannot declare itself the successor or continuator of the USSR, since this is not a country, but an organization. Moreover, this is international organization that was created illegitimately and the countries belonging to it allegedly declared themselves independent from the USSR. Therefore, Because they independent of the USSR, they cannot be the successor or continuator of the USSR. 6. Therefore, Yeltsin's letter to the UN dated December 24, 1991 about membership in the UN is illegitimate, especially since Yeltsin was never the president of the USSR or the RSFSR. Because the citizens of the USSR voted to preserve the USSR in the All-Union referendum of the USSR on March 17, 1991, and there is no president in the Soviet legislation of the USSR. Therefore, the UN had no right to accept the Russian Federation as a UN member in the place of the USSR. Conclusion: this means that the UN has been working illegally for 30 years. In accordance with its charter, the UN cannot exist and work without the USSR, which is a permanent member of the UN Security Council and is a member of the UN Trusteeship Council. But the USSR still exists legally and physically, so the UN should be completely cleansed and its entire current composition should be completely replaced with a new one from the people. And the old UN composition should be brought to justice, in court that will be similar to the Nuremberg Tribunal of 1945–1946. As this people of the old UN composition conducted their illegitimate and criminal activities as fascists of Hitlerite Germany during the Second World War. Absolutely all projects, documents, decisions and decrees, contracts, etc. from the UN, including on the published over the past 30 years during the illegitimate presence in the UN of an organized criminal group called the Russian Federation, Russia, and members of a criminal organization called the Commonwealth of Independent States, CIS, are invalid. Illegal. Therefore, absolutely all restrictions associated with a fake, in all countries must be lifted immediately. Can the UN work and exist without the USSR? No. Grounds. The absence of the USSR in the UN leads to a constitutional crisis that completely paralyzes the UN. Since the place of the USSR as a permanent member in the Security Council was left without the owner, see Article 23(1) of the UN Charter. The disappearance of a permanent member of the Security Council would have had constitutional implications also beyond the activities of the Security Council itself. Under Article 86(1) of the UN Charter, a permanent member of the Security Council is also automatically seated on the Trusteeship Council. Under Article 108 of the UN Charter, the ratification by all 5 permanent members of the Security Council is one of the conditions required for a charter amendment to take effect. In the UN Charter, in Article 23 of Chapter 5, Security Council, the composition of the UN Security Council is clearly indicated and even permanent members with the name of the country are listed. All permanent members are still listed there under the same name of countries, and there is no name of the Russian Federation. I am citing this article, Chapter 5, the Security Council. Composition. Article 23(1). The Security Council shall consist of 15 members of the United Nations. The Republic of China, France, the Union of Soviet Socialist Republics, the United Kingdom of Great Britain and Northern Ireland, and the United States of America shall be permanent members of the Security Council. The General Assembly shall elect 10 other members of the United Nations to be non-permanent members of the Security Council, due regard being specially paid. In the first instance, to the contribution of members of the United Nations to the maintenance of international peace and security and to the other purposes of the organization. And also to equitable geographical distribution. 2. The non-permanent members of the Security Council shall be elected for a term of 2 years. In the first election of the non-permanent members after the increase of the membership of the Security Council from 11 to 15. 2 of the 4 additional members shall be chosen for a term of 1 year. A retiring member shall not be eligible for immediate re-election. 3. Each member of the Security Council shall have 1 representative. Below are other articles of the UN Charter that clearly and unequivocally state that the UN cannot work and exist without at least 1 permanent member of the UN Security Council, that is, without the USSR. Quote from Charter of the United Nations, Functions and Powers. Article 24. 1. In order to ensure prompt and effective action by the United Nations, its members confer on the Security Council primary responsibility for the maintenance of international peace and security, and agree that in carrying out its duties under this responsibility the Security Council acts on their behalf. Article 25. The members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present Charter. Voting. Article 27. 1. Each member of the Security Council shall have 1 vote. 2. Decisions of the Security Council on procedural matters shall be made by an affirmative vote of 9 members. 3. Decisions of the Security Council on all other matters shall be made by an affirmative vote of 9 members including the concurring votes of the permanent members, provided that in decisions under Chapter 6, and under Paragraph 3 of Article 52, a party to a dispute shall abstain from voting. Procedure. Article 28. 1. The Security Council shall be so organized as to be able to function continuously. Each member of the Security Council shall for this purpose be represented at all times at the seat of the organization. Chapter 13. The Trusteeship Council. Composition. Article 86. 1. The Trusteeship Council shall consist of the following members of the United Nations. 1. Those members administering trust territories. 2. Such of those members mentioned by name in Article 23 as are not administering trust territories, and 3. As many other members elected for 3-year terms by the General Assembly as may be necessary to ensure that the total number of members of the Trusteeship Council is equally divided between those members of the United Nations which administer trust territories and those which do not. 2. Each member of the Trusteeship Council shall designate 1 specially qualified person to represent it therein. Chapter 14. The International Court of Justice. Article 92. The International Court of Justice shall be the principal judicial organ of the United Nations. It shall function in accordance with the annexed statute, which is based upon the Statute of the Permanent Court of International Justice and forms an integral part of the present Charter. Article 93. 1. All members of the United Nations are ipso facto parties to the Statute of the International Court of Justice. Article 95. Nothing in the present Charter shall prevent members of the United Nations from entrusting the solution of their differences to other tribunals by virtue of agreements already in existence or which may be concluded in the future. Chapter 18. Amendments. Article 108. Amendments to the present Charter shall come into force for all members of the United Nations when they have been adopted by a vote of 2/3 of the members of the General Assembly and ratified in accordance with their respective constitutional processes by 2/3 of the members of the United Nations, including all the permanent members of the Security Council. Place: Bangalore. Date: 14 July 2021. Note: PIL on USSR case is a lawsuit in the form of a public interest litigation, PIL, on the USSR case, which I filed in the Supreme Court of India on 7 July 2020 regarding the unlawful collapse of the Soviet Union and the illegality of any activity of organized crime group, Russian Federation, Russia, and the CIS, and the so-called former republics, of the USSR, and the UN and its bodies, including WHO, within the framework of the PIL under the case number, Diary number 14060 of 2020.